Hi, Judicial Watch President Tom Fitton here with a special Judicial Watch issue update on the Clinton email investigation. Judicial Watch has been taking testimony and gathering evidence on the Clinton email issue, and joining us to talk about all of this today and what we've found is Judicial Watch Senior Attorney Ramona Kotka. Ramona, thanks for joining us.
Thank you for having me.
I know you've been busy, you and your colleagues in the legal department of Judicial Watch, taking discovery on the Clinton email issue, and I know many Americans are going to be surprised that there are witnesses still being questioned under oath in litigation about the Clinton email scandal. And I guess the first question out of the bat is, what Judicial Watch lawsuit has resulted in Clinton email witnesses having to come and be questioned by you and your colleagues under oath?
Well, should we start with, you want me to start with what the lawsuit is about? Or
yeah, because I think people will be surprised to know that there's another big scandal tied to this.
Sure, absolutely. So this lawsuit has been pending since 2014, and we asked for records from the State Department, from Secretary Clinton's office with respect to email communications and records being provided about the talking points and updates that were provided to then Ambassador Susan Rice following the Benghazi attacks in Benghazi in September of 2012.
So we're asking about the big lies told by the Obama gang on Benghazi. We wanted Hillary's emails.
Well, right. So we've had a similar case prior to this. We've asked these records, but from Ambassador Rice's office, right, and we didn't receive any of Clinton's emails. So we then filed the lawsuit from her office, directly from her office, as to where are her emails. So that's what prompted this lawsuit after we discovered the Ben Rhodes memo in the previous case.
You know, it's really interesting because I remember talking with you about this back in 2014, and people wonder, well, how does Judicial Watch figure out what to do? And it was just a discussion in the office of where are Hillary's emails? We haven't gotten any in this other Benghazi case. What are we going to do?
Right. So what we did is we submitted another FOIA request specifically to her office, and then we filed the lawsuit. This was back in 2014, and now we're in 2019.
Well, now, and I think people will be interested to know that you found something weird in that lawsuit that suggested they were hiding something from us.
Right, in the current one.
Yeah, in this lawsuit.
In this current one. Yeah, so we filed the lawsuit in July of 2014. In September, they said they're going to conduct a search and that they would provide the documents that resulted from the search by November. We received 4 documents in November, all of which were produced in the previous lawsuit. And then in December 5th, the State Department also said, we're going to also give you a draft Vaughn. What is basically is a legal document just showing the explanations as for the redactions, the basis for redactions that the State Department had made.
And redactions are?
Redactions are information that is excluded from production because the government may have an interest, either the information is classified or deliberative process or pertains to personal information. So that's under the FOIA exemptions, the Freedom of Information Act exemptions. Right. So fast forward to our other discussion in December of 2014, when we received the 4 documents, and we again said, I don't see any of Hillary's emails in here. And so once we received the draft on December 5th, we asked the State Department, because at that point, they said they've completed the search, they've completed producing all the documents they have that are responsive to our FOIA request, and they were trying to see if we would settle the case, meaning if we would just dismiss it. So after following our conversation, we went back to the Department of Justice and asked them, well, we need to know what you searched, and specifically because we were looking for Hillary Clinton's emails. So in December, they said, okay, well, let's look into it. And so we asked for a draft search declaration. They said, we filed a status report on December 31st. They said they need additional time to provide a draft search declaration. And then we filed another status report on February 2nd of 2015. And that was the first time they said they need to, they need to conduct an additional search.
So if I recall that document, so this is Benghazi,
Yes.
an important issue. We're asking for Hillary Clinton's emails, and by that time they already knew her emails were out there. Look, they've known for some time, but they officially knew since they had been sent back to them by that time.
December 5th was I'm sorry to interrupt,
Yeah.
but December 5th was the same date. They received, so in the discovery in this case, by noon, the State Department officials had picked up the records, and the director of IPS had gotten a call that the State Department received Hillary Clinton's emails. They
So
had 12 banker boxes.
A dozen boxes, yeah.
At 4 o'clock, we received the draft the draft Vaughn Index from DOJ attorney. At that point, the State Department, and when we received the draft Vaughn, the reason I'm mentioning that of significance, because that's for purposes of trying to settle the case.
They wanted to shut the case down before they told us they had the emails.
Exactly.
Before they had to tell us they had the emails. But
Exactly.
Ramona, being the excellent lawyer you are,
Wow.
pushed back and said, we want more information. And in February, as you point out, they say, we gave Judicial Watch everything, but there are other documents we may have to
There's
review.
an additional search we need to do.
And then in March, a few weeks later, it's leaked to the New York Times that their Hillary Clinton emails are out there.
Yes.
And as I've said, and I've made the argument, no one's credibly countered it, is that they leaked it. They wanted this material to come out in a friendly place like the New York Times because they didn't want it to come out directly to Judicial Watch, because it was our litigation that was forcing their hand here.
Well, let's point out the fact, this is undisputed. So by April, so you're talking about the early March press release, newspaper
New York
reports,
Times,
right? The
right.
New York Times report. By April, the State Department had committed in the February court filing that they would complete the search and would provide the production. So by April, within a month after the New York Times released the story, we would have known about
We
it.
were going to be told in April. They would have had to tell us at the time.
We would have, yes.
So, fast forwarding.
Okay.
It's a few years later. We've asked for, there was another Freedom of Information Act case where we did receive some discovery for the shenanigans. In that case, we had actually shut the case down after they lied to us about the Clinton emails. That was
Right.
reopened by Judge Emmett Sullivan. He was upset about that issue too. I'm not aware of any other cases under FOIA being reopened because the government lied about their records being hidden, but that happened with Hillary Clinton, another historic first for Mrs. Clinton.
I think we have another pending lawsuit that's been reopened, actually.
But there was
But,
there was a second one after that
Right,
was reopened.
right.
Yeah, so that was twice. So we received some discovery there. We took some eyewitness testimony from people like Cheryl Mills and Yuma Abedin. Mills was a top deputy of Hillary Clinton. Abedin was too. Abedin had an email on the system. But there was other discovery issues we wanted to pursue with the judge in this Benghazi case we're talking about, Judge Lamberth. And so he finally ruled in late last year. Can you talk about what Judge Lamberth found and what he wants us to do, or what he wanted us to do?
Sure. So really our argument to the court, I mean, we still have the argument, right? What was the purpose of Secretary Clinton's use of her email to avoid FOIA? So that's still a component of the discovery that Judge Lamberth granted and permitted Judicial Watch in this case.
So say that one more time. What was the purpose of her?
Was her use of the ClintonEmail.com to avoid FOIA?
Disclosure.
Yes,
Yeah.
to avoid disclosing under FOIA. And but another argument that we made to Judge Lamberth, which Judge Lamberth agreed with us, is during this time, State Department knew that they were asking for Secretary Clinton's emails back. They knew since the summer of 2014 that she had Benghazi-related emails. Never during this period of time did they ever disclose to us that they had Secretary Clinton's emails relating to Benghazi. So part of our argument to the court was there bad faith? Should the State Department have disclosed this to Judicial Watch and to the court?
Now, Judge Lamberth agreed with you in spades on that.
Yes, he did.
And
It would be
see a
hard
lot
not
of,
to.
we see a lot of federal court decisions about FOIA and whether agencies are following the law. It's rare to see a court decision that excoriates a principal like Mrs. Clinton, to government agencies like the Justice Department and State Department, and then authorizes people to have to come in and testify under oath. Can you talk about what Judge Lamberth found specifically?
Right. So the other thing about why this case is a little bit broader than the previous cases, which Judge Lamberth also found in his ruling, is Benghazi. Obviously, there's a lot about Benghazi that's been talked about. Obviously, there were a lot of questions about Benghazi, especially after Susan Rice came on the Sunday morning talk shows to blame a YouTube video, and everybody had watched it, and everybody was wondering, how is this not a terrorist attack, and how are you blaming this on a protest?
Right.
So part of Judge Lamberth's ruling was to permit discovery into the developments and what the State Department knew about the Benghazi attacks during this time frame. And were they not searching Secretary Clinton's emails to avoid disclosing information that they had knowledge, that she had knowledge?
So he granted us discovery into the issue that you raised about whether she was trying to avoid FOIA disclosure generally, and whether the State Department and Mrs. Clinton perhaps didn't want this disclosure in part because they were worried about what might be in there about Benghazi.
Correct.
So Benghazi's in the news again. I mean, in the sense that we're pursuing Benghazi in discovery.
Yeah.
And he also was upset about messing with the court process too, wasn't he?
Oh, absolutely. So what is unprecedented, I mean, it's very rare, it's not that it's unprecedented, but it's very rare for a court to permit a deposition of an attorney of a party. But in this case, because there are questions as to what the Department of Justice attorneys knew when they were submitting information to the court about the status of the search in this case, and what the State Department attorneys knew, Judge Lamberth actually permitted us to depose State Department attorneys in this case.
I mean, if I recall, he said something about he was concerned that they tried to hoodwink the court.
Oh, yeah.
So, I mean, that's... so you get the question. You were able to question you and your colleagues, and I think we've had 5 attorneys working on this case since then. In terms of, he authorized us to bring in witnesses, and
yes,
and so these are people who come in and get questioned under oath directly by our attorneys, right?
Correct, right, and it can be in different formats. It can be as a deposition and oral questions, or it can be in written format as an interrogatory.
So, it was about a dozen witnesses, more or less.
Yep.
Now we've completed the authorized discovery, more or less. Am I correct?
We have. That's been authorized to date.
So, we've deposed a bunch of people, gotten lots of documents, and what have we found?
Where do we begin?
So let's go through. Let's go through. Maybe let's start with those that we sent written questions to and they responded to under oath. And one of the more significant individuals there was the FBI official who was in theory leading the Clinton email investigation, Bill Priestep.
Right.
Senior FBI official had to respond to Judicial Watch questions under oath about what he did to investigate the Clinton email issue, and what were the revelations in his answers? So
we found some important information in his answers. One item was that there was confirmation under oath that the FBI had recovered Secretary Clinton's emails in the Obama White House, in the executive office of President Obama.
Oh, so Hillary Clinton took 60,000 emails with her, right? She deleted half of them. And the FBI, in theory, was supposed to try to find them.
Right.
And in efforts to try to find them, they found them in the Obama White House.
We found some in the Obama White House.
Doesn't that kind of help? Well, I won't force this conclusion on you. In my view, it shows why the email investigation of Hillary Clinton was a sham. Because it demonstrates, the fact that they found her emails all over the executive office of the president implicates the Obama White House in the scandal, because they knew she was using this system secretly, or at least that's one conclusion that can be drawn with this extraordinary admission by the FBI. So they had to find her emails in the Obama White House. Unbelievable. And what was the other thing they found?
The other thing,
Or he admitted to?
right. The other admission by Bill Priestap is that the FBI had reviewed approximately just under 49,000 emails to the ClintonEmail.com domain as a result of the FBI search warrant on the laptop of Anthony Weiner.
So Anthony Weiner had a laptop, and he was at the time married to Yuma Abedin.
Right.
And now the news there is that Abedin and Hillary Clinton and Chelsea Clinton were the only 3 people on her secret system, or so we've been told. Right?
Right. I mean, there may have been other individuals, but not related to the State Department.
Right. Well, Chelsea Clinton.
Right. But
well, it was the Clinton Foundation. The Clinton Foundation was running the State Department at the time anyway. So, so Abedin being married, she has all these emails on his laptop, and Weiner is a sex criminal. Some of that material turned out to be classified.
Well, that was part of the review.
So thanks to Hillary Clinton's use of her system, and Abedin's similarly misuse of that system, there was classified information, it looks like, among that 49,000 on Anthony Weiner's laptop.
Right.
49,000 emails.
49,000 emails. That's a lot of emails.
And all of that came out after, quote, she was exonerated.
Yes, I believe. Right,
Yeah.
right. It was after the July 2016 press conference.
So the FBI official admits there's Clinton emails in the Obama White House and nearly 50,000 Clinton emails, government emails, improperly on. He didn't admit they were improperly on his laptop, but they were improperly on his laptop, Anthony Weiner's laptop. So let's move on to, let's stick with the security issue, Eric Boswell.
Okay.
Now, Eric Boswell was the senior security official for the State Department.
Right.
I don't know what his exact title is, but it's a senior guy involved with making sure that people are following the rules related to the handling classified information and other things.
Right. He's responsible to make sure people are following the rules and protecting any classified information. And
we deposed him under oath, right?
we deposed Ambassador Boswell under oath. Some of the information that we discovered as a result of the deposition was one thing he did say is when Secretary Clinton and her team came on board to the State Department, he described her and her senior aides as wedded to their BlackBerries. They wanted them by their desks, coming after the campaign trails, so they wanted to have access. That led to
Why is that a problem?
Well, because...
I mean, we're all wedded to our devices, aren't we?
Yes, but we're also not the Secretary of State.
Right.
And we're also not necessarily transmitting classified information. I'm not.
So if you're in the Secretary of State and you're in a secure place in the State Department, having unsecure phones is a security risk, and I guess that was his concern.
Right. And he testified that Secretary Clinton was warned twice, once in 2009 and once in 2011, with respect to security issues related to use of BlackBerries, in specific with respect to classified information.
And what about, it was also personal emails? Was that a discussion too?
I believe so, yeah.
So she was warned. How was she warned?
One was there was an official memo that was provided to Cheryl Mills, who provided a copy to Secretary Clinton from Ambassador Boswell. That was I believe in 2009.
And Cheryl Mills was her top person.
Right. She was her chief of staff. She was one of the individuals who people went through to, communicate with Secretary Clinton.
And Boswell is the one that Hillary Clinton talked to about this issue. It wasn't like I sent her an email and I hope she saw it. There was a communication about it, wasn't there?
There was communication, and Secretary Clinton had communicated that she understood the concerns, the security concerns.
In person?
Yes.
Okay, so Hillary Clinton was warned twice about using her BlackBerry and the security risks of personal email use. How does that comport with the finding by the FBI director then, James Comey, that she didn't have the necessary intent in her terms of her mishandling classified information? I guess that's a rhetorical question.
Yes.
But this is why, and I want to take a step back, this sort of information that's coming out as a result of our discovery, we have to recall that the Justice Department and the State Department under the Trump administration, I can't imagine President Trump was too thrilled about this or had any practical say in it, opposed our efforts to get this information.
Oh, well, they've been opposing our efforts every step along the way.
And even once we were allowed to get it, they still were obstructing us.
I mean,
And this is why, because this is the sort of material, and you know, my view, this material obviously has an impact on what the judge is ultimately going to rule in our case, but it also has an educational impact and increases, in my view, public pressure on the Justice Department to reopen the criminal investigation and what Mrs. Clinton did.
right.
So, and I guess going back to the beginning, let's talk about Justin Cooper, who was,
Okay.
now Mrs. Clinton promised the Clinton Foundation would have nothing to do with the State Department. Well, other than the Clinton Foundation official setting up her private email account.
Right. So
And we deposed this person.
we did. He was actually, I think, our first deposition. Our first deposition was of Mr. Cooper.
And it was Justin Cooper, who was a Clinton Foundation official at the, I don't know if he still is or not, but he was.
He's no longer,
Yeah.
based on his testimony, but he was. And he actually registered the ClintonEmail.com domain in January of 2009.
Well, what I thought about was interesting about his testimony was how it conflicted with testimony we had previously received from Yuma Abedin.
Correct. So when we asked the follow-up question of who made the request to register the domain name, his answer was it would have been through a conversation with Huma Abedin. And what you're referring to, Ms. Abedin's testimony from 2016, she says she didn't know about the server until she read about it in the newspaper, like you and I.
You know, and if I recall her testimony, she said that she found out about it, that, you know, she was asking about emails and she said it was already set up through the system. They had the Clinton server set up and she could be part of it. Who do you think is telling the truth?
Well, obviously Mr. Cooper's telling the truth because he's the one who registered the domain name. And somebody had to make the request to register it.
She's saying I wasn't involved in getting him to do that. He's saying she was. Does he have an interest in blaming her, or I mean, I don't know how to read that. I could read it. I could construct two conspiracies around it, but which one do you think?
Well, his testimony. I mean, and we also have it by proof of documents as well. So you get the testimony as to what people recollect at this point, but you also look at the documents that we've received in discovery. And Mr. Cooper's testimony is that Huma Abedin was the point of contact whenever there were email issues, whenever there were issues with Secretary Clinton's emails. And the documents and the emails that we've received confirm that.
So, based on what you're telling me, it sounds to me like maybe Ms. Abedin didn't want it to be known or had an interest in making it known that as a State Department official she didn't set this up. That she didn't have a role in setting it up. I don't know if she set it up or not technically. Quite literally, yeah.
But
the lawyers, you got to be very specific. And this is the sort of thing. Our listeners, you can go look at the Abedin testimony. The transcript is available. Justin Cooper's transcript is available. We reference the documents that we're talking about in the transcripts.
Right.
So pretty much everything we're talking about here is available online at judicialwatch.org. So.
Correct. The entire and the full transcripts of the depositions are available on our website.
And we have press releases that sum it up all up too, so it makes it a lot easier to get through some of it. So we go from Justin Cooper to, we talked about Eric Boswell, we talked about Bill Priestep. Then who should we talk about next?
Well, do you want to talk about John Hackett?
Well, John Hackett isn't even out yet. So we're breaking news as we speak about John Hackett's testimony. And it's probably there's other interesting material received, but this is a witness, in my view, who's blown it wide open.
Right.
Am I exaggerating?
No.
So John Hackett, let's talk about who John Hackett is.
So Mr. Hackett is a former director of IPS. IPS is the information of program services, I believe, of programs and services at the State Department, basically heading all of the entire FOIA program for the State Department. He came on board as the deputy director and then was elevated to director. He came on board in July of 2013, during the time that Cheryl Walter, who he also deposed, was at the time she was the director of IPS. In his testimony for the first, in July of 2013, he saw a photograph of Secretary Clinton holding a BlackBerry on the military plane that I think a lot of us has seen since then. So, and he saw it.
That's the one where she has the dark glasses?
Correct,
Yeah.
correct.
Yeah.
And after his testimony, looking up why it came out back during that time, I believe that's when she opened her Twitter account. And actually that was the photograph that she selected,
For
I
her
believe,
Twitter
for
account.
her Twitter account.
So Hillary Clinton liked
So-
that photo. Showing her using,
it was posted
using the
with
illegal
that,
BlackBerry.
But that was sort of the context of why it appeared, because I believe the photograph existed since 2011. I think it was because it was taken while she was at the State Department. So it predates 2013. He sees the photograph, and Mr. Hackett testified that raised concerns, red flags for him with respect, what is this BlackBerry? Is this a State Department issued BlackBerry? What does that mean for FOIA? Does that mean that there's an email associated with the BlackBerry? And how are we responding to FOIA requests relating to Secretary Clinton's emails? So he alerted.
Sounds like a troublemaker.
Right. He alerted his boss, the director at the time, Cheryl Walter, who then she elevated it to her boss, who was at the time Margaret Grayfeld. And his testimony is they did research, they assigned somebody to do an investigation as to what this email is about, but of significance is he recommended, and the director at the time, Cheryl Walter, agreed with him, and apparently there was a directive issued not to submit any more no records located responses to FOIA requests asking for Secretary Clinton's emails.
But they were a little late to the dance in that regard, because they already had known about her email system. And just take a step back, because part of this discovery meant us getting documents that we otherwise would not have been able to get under the Freedom of Information Act.
Correct.
And they gave us documents showing that they knew and lied about her email usage prior to Hackett looking at that photo and saying, oh my gosh, what's going on here?
Well, we know actually from another testimony in this case, one of the attorneys, Gene Smolansky, his testimony that they were aware of Secretary Clinton's email relating to Benghazi as early as in 2012.
And weren't they consulting the White House about it?
Well, at that point, his testimony is that they were consulting the Department of Justice.
And when did they start consulting the Obama White House about it?
So the Obama White House, as to information that we discovered in this case,
Right.
Became involved in December of 2012, also in 2012, in regards to a FOIA request. Are you talking about the Crew request?
Yes.
A FOIA request from Crew, Citizens
Crew.
for Responsibility and Ethics in Washington.
A left-wing group founded, modeled based on Judicial Watch, of all things.
Right, and they had submitted a request for all records showing the number of email accounts that she used and her email address.
So they had a request that was, boom, right on target. They
Yeah.
had, I think, asked across multiple agencies for alias requests of senior
Right.
officials.
Right.
And with the Hillary Clinton request, oh my gosh, they asked about documents that would have revealed her email system.
Right.
And so they consulted with the Obama White House.
They did.
the White House counsel.
White House counsel's office.
And what was the response they gave to Crew?
They gave a no records response in May of 2013.
Okay, so I'm going to put a headline on this.
Okay.
The Obama White House coordinated the lies and obstruction of information about the Clinton email usage in October 2012 and early 2013. I mean, that's the evidence, isn't it?
In October of 2012?
December of 12, late 2012,
Late 2012.
early 2013.
Okay.
And then this other witness, John Hackett, comes in and he says, so that after all those lies that occurred, he blows the whistle. And he tells the boss who had previously lied, it looks like, to Crew, well, you know, she's using the system, she's obviously using a BlackBerry.
Right.
And they said, well, we're going to have to stop lying. I mean, I'm putting an editorial spin on it, but that's what this evidence suggests, that because of this one person, the State Department went silent. They didn't start telling the truth, but they went silent about her emails.
Right. They never, as far as we know, they never issued a correction to Crew.
So then the email issue becomes more public, at least within the State Department. And what is he's seeing all sorts of improprieties.
Right. So you have
this witness, John Hackett.
You have July 2013. This becomes an issue. So and then you have fast forward to August of. So it's kind of this time frame, July, August 2013, when they're trying to figure out, has the State Department ever issued Secretary Clinton a BlackBerry? And I believe Mr. Hackett testified that they made the inquiry and were told that she never issued that she was never issued a BlackBerry, a State Department BlackBerry.
So it was a personal BlackBerry.
So it was a personal BlackBerry, but nonetheless, that begs the question: she's using this on a military plane while she's Secretary of State. What's the email associated with a BlackBerry?
Right.
Then Mr. Hackett also testified again towards the end of 2013 and leading into 2014. There's another FOIA request where that, as a result of the search that was conducted, the State Department had located some records with her email address, the HDR22 at clintonemail.com. So we know that by the time, specific to this FOIA request and this litigation, we know that even before we filed this lawsuit, State Department officials were aware of Secretary Clinton's email use. Oh, and even Cheryl Walter, who was the director at the time of IPS, she's testified that there were not rumors, I can't remember the exact word, but speculations. Speculations about.
I use that term all the time, right? Oh, we were having speculations about someone's email usage.
Yes, I believe that was the term that she
Yes,
used
yes.
About her email use.
And of course,
And
that's a
this is in
disingenuous way of
2000
putting it, isn't it?
Correct. And I mean, because at
They
that
all
point,
know.
if they're, the follow-up question to that is, well, what did the State Department do? What did you do as a result to make sure, to determine whether these speculations are true or not?
Well, and if you want to know why the court in our case is mad, we had indications all that was going on. We didn't have the detail, but we knew they were playing a game, and the court recognized they were playing a game. And the frustrating thing from my end is that you had the State Department and Justice Department playing a game under Obama, and and still to this day, the Justice Department and State Department have defended this misconduct. And Judge Lambert attacked the Justice Department and State Department for still prevaricating with him. Not under Obama, but during this administration. So President Trump, in my view, needs to start asking why they're still defending Hillary and the State Department misconduct here. But we're still going to get more on this Hackett testimony.
Right.
Because then it comes out that all the emails get shipped back to the State Department, and Hackett's asking more impertinent questions.
Right, right. And one of them being because they have 12 banker boxes of emails that are returned, and then they find out, and by they, John Hackett and others at State Department, that 30,000 were deleted and were
Right.
not returned and deemed personal. So Mr. Hackett, as the director of IPS, obviously one of the important, what was the protocol, what were the guidelines, what were the parameters that Secretary Clinton's team used to determine that 30,000 emails, because that's not 3 emails, it's 30,000. That's a significant amount, that they were not official federal records. And he raised that with with Patrick Kennedy, who was then the Undersecretary for Management. And according to Mr. Hackett testified that Mr. Kennedy would make that request of Secretary Clinton's team. However, by the time Mr. Hackett had left the State Department, Secretary Clinton's team had never provided that information.
So Kennedy since has resigned, and he was the #1 administrator at the State Department. He was the top dog in terms of administration. And we deposed him in the other case, right?
We did.
And he was the I'm not responsible for anything guy, right? Well, one of many, but.
Correct.
And the other thing it's important to know, because we have all sorts of various litigation going on, Mrs. Clinton had no right to any of the emails she took, and arguably all of those were government records. Whether they would be subject to FOIA is another question,
Right.
if they were personal. So the idea that, since when does a non-governmental official get to decide what is subject to FOIA or what is a government record or not?
Well, it shouldn't be. And that is why Mr. Hackett actually in his testimony, I think he used the term, he was emphatic. And he said he rarely used a strong tone with any of his superiors.
Well, the State
But
Department being
at
a
the
nice
State
little
Department-
bureaucracy where everyone
but
gets along, right?
He was on this issue because it was not only highly unusual, but you had to make sure that you conformed with the Federal Records Act.
The State Department at that time could have asked, well, as we've highlighted in other litigation, could have asked the Justice Department to go get those emails. Don't let them be deleted. We didn't get everything.
In 2014, as far as we know, they hadn't been deleted.
So, to be clear, a State Department official warned his colleagues, his supervisors, what's going on with these deleted emails, or they're about to be deleted and nothing was done to stop
Or the
them from-
unreturned emails.
The unreturned emails.
Right.
So they hadn't been deleted yet. So the State Department could have stopped them, in theory, from being deleted.
Oh, they could have made the request at that point.
Unbelievable. And it gets worse because, we'll take a step back on the 33,000. We now know they weren't personal emails because Judicial Watch has received some of the emails that the FBI did recover.
Right.
And it was classified material, 5,000 records of government material that were turned over to the State Department. So
Right.
it was just full of government material. Now, I want to talk about the person who deleted that later because it's another whole other topic. But Hackett also exposed, because to me this is all a description of a criminal cover-up in my view, but that also involved the State Department knowingly allowing classified information to go out the door improperly
Okay.
to protect Hillary Clinton. So that's, what did he testify along those lines?
So this, Mr. Hackett's testimony in this regard is with respect to the State Department's review process of the emails that she returned, the 30,000 emails that she returned. And he actually, he testified that in his view there was interference in the normal review process. It was done by attorney Catherine Duvall, and the normal FOIA review process is done by certain officials who know FOIA, who know what they're supposed to look for, and it was not done by them. It was done by a different team. But then also with respect to documents where other agencies would have an interest in the documents, Mr. Hackett testified that when he requested, or he asked, were these other agencies consulted with? Because that would be the normal process to make sure, that any information they deemed classified would be protected. And he testified that it wasn't the normal individuals in these other agencies who were part of this review process.
And in addition to that, there was specific allegations he made that pressure to underclassify material that was the State Department's control on Benghazi.
Right, and the other part of his testimony was rather than for classified information, you use a certain exemption. It's a B1 exemption. And rather than using a B1 exemption, State Department officials were told to use the B5 exemption, which is deliberative process. And Mr. Hackett's concern about that was if it's B5 and it's not properly labeled as classified, it can be put even on the State Department system that's not the classified system. So
Puts it at risk.
Puts it at risk.
And it was disclosed to Congress as B5. So Congress couldn't make the protections in normally. So this is pretty serious. This is a pretty serious issue. And I recall looking at many Clinton emails, and I may have told you, and I've always said publicly that, and it's always hard for a transparency organization to complain, oh, we got material that we shouldn't have gotten. But our experience is you kind of know typically what is withheld from government documents and what you typically don't get.
Right.
And I noticed in the production of the Clinton emails that there was material that I would have presumed to have been classified that was not classified. That was either public, it was generally public. I'm not even talking about material that obviously I can't see what I can't see. But they were, I'm convinced, giving us material that otherwise would have been classified, which kind of fits in with his concern that they were underclassifying material. So it puts classified material at risk, and it also conveniently protects Mrs. Clinton from further criminal exposure by decreasing the amount of classified material tied to her system. And who was, did he say who was given that pressure?
No. Well, the only individual I believe he identified is Catherine Duvall, who was the attorney who sort of led the review process, and Richard Vicek, perhaps. But right offhand, I can't recall if he testified as to other.
So the State Department was protecting Hillary Clinton in underclassifying material. That's what the testimony suggests, in my view. But what else did he, I don't recall, did he testify anything else of interest?
Yes, of great interest in our case. In the summer of 2014, when we had our FOIA request, Mr. Hackett once again testified that Secretary Clinton's email had come up. One of the issues that he testified, or part of his testimony was during that time frame, records were being produced from the State Department to at that point, the Benghazi Select Committee had already been formed.
The Benghazi Committee had gotten some emails, yeah.
Correct. And so the documents that were being produced in August included some of her emails, a small number of her emails. And he was given a heads up by the attorney who was handling our FOIA lawsuit and who was also involved in the production to the Benghazi Select Committee that it may generate publicity to the State Department.
And this was when, in the summer of 2014?
Yes.
So,
August or September of 2014 is when Mr. Hackett testified.
And they were trying to get us off the scent on the Clinton emails. I mean, just to be clear, I want to go back. We had made that second request specifically to get at Clinton emails because we
Correct.
weren't sure if our initial lawsuit on Benghazi had covered her email system adequately or any emails that she had created. I remember thinking at the time, I don't remember if I discussed it with you, well, maybe she didn't have any emails. But
I think that was part of the discussion. Well, we should ask for them and find out.
Trust but verify, right? And they were lying to us. I mean, that's what was going on, and they had known well, of course, the State Department had known since Hillary Clinton began using that email system in 2009.
Right.
So it's not like look, Hillary Clinton knew she was using the system, her chief of staff knew she was using the system, her top counselor, Yuma Abedin, not only knew she was using the system, but she was on that system with her, had classified material in her email account as well. And I want to talk generally about these other witnesses, and we don't need to get into specifics of who they are, but we talked to a lot of former and current officials at the State Department who are in positions administratively to be aware of, or one way or another, as to how this was going, what was going on, and I guess unsurprising but disappointing testimony from them in terms of their supposed ignorance on it.
Right. I mean, well, one part of that, which we expected, although, you know, it's still surprising the lack of recollection by a lot of the witnesses that we deposed.
They can't
with
remember
respect-
anything about the Clinton emails.
We deposed Mr. Finney, who was in charge of the records. He was like the record manager for the secretary's office. And Mr. Finney was made aware of issues relating to her emails in the summer of 2013 when Mr. Hackett brought it up.
And there's a document
There's
to that.
testimony.
Isn't there a document to that effect?
It may be. There's so many documents.
I may be remembering
maybe.
another document.
Maybe.
But you asked him,
wanna
did he
speak.
remember that discussion?
And there is very little recollection as to, and you know, the thing that's surprising is,
Well, to be fair,
so many times,
Go ahead.
yeah.
Go ahead.
But there's some, I mean, if you look, December of 2012, right, or even before that, when Mr. Smolansky testified that there were Secretary Clinton's Benghazi-related emails in right after the attacks, when he was consulting with DOJ. Now his testimony is, oh well, we didn't really pay attention to the email, but this is for purposes of responding to FOIA and congressional records. So to determine what to search, you have to look at the source of the record. So if you see an email address for Secretary Clinton relating to State Department business, that's a system of records. That's a source you're supposed to be searching. But my point being, fall, you know, late fall, early winter of 2012, December of 2012, you have July of 2013, summer of 2013, then you've got again, you know, end of 2013, early 2014, when her email comes up in another FOIA request. Then you have summer of 2014, when they know that they have Secretary Clinton, again, they still know they have Secretary Clinton emails relating to Benghazi. And during all these times, there's so much of the testimony was, I just don't recall, I don't recall.
It reminds me of the, you know, you see the little statuettes often of the three monkeys, see no evil, hear no evil, speak no evil. And that reminds me of the bureaucracy. The State Department bureaucracy, the deep state, if you will, was and remains in cover-up mode for Hillary Clinton. Which probably leads us to the thing that everyone remembers as it relates to Hillary Clinton's emails. It's the infamous deletion of the 33,000 emails. And one of the extraordinary developments in this case is we were able to talk to Mrs. Clinton's personal lawyer who deleted those emails. And you know, she wasn't, and her name is Heather Samuelson, but I think it's important to realize, and it didn't click with me until her testimony, well, she just wasn't Hillary Clinton's lawyer. She just didn't drop out of the sky and become Hillary Clinton's lawyer. But she had other positions in the Obama administration that are going to be shocking to people.
Right. Well, she worked under Secretary Clinton as the White House Liaison's office at the State Department during her tenure.
So a sensitive political position in the State Department.
Sensitive political position in the State Department, and she was in charge of hiring all of the political appointees during Secretary Clinton's tenure.
So if you were a campaign volunteer or a donor or a Clinton Foundation funder and you wanted a job, you had to go through her to get one.
Well, she testified that on occasions, Doug Band, who's a Clinton Foundation official, that he had sent several requests, you know, recommending certain individuals to be hired and considered.
So her testimony on what she knew and when she knew about the Clinton email usage is rather
significant.
Curious.
It's very significant. It seems to be in conflict with at least with the notes that were taken by the FBI officials in the 302.
So the FBI interviewed her,
Right.
and they have a document of that interview. It's called a 302 report.
Right.
And the 302 report, what they ask her generally that you were interested in?
Well, the notation is that she informed the FBI that she didn't know about the fact that she used a private email account until after she left the State Department, until she became her attorney in 2014.
Huh. And what did she tell you? Under oath later.
Under oath, her testimony is that she became aware that Secretary Clinton used her a personal email while she was at the State Department.
So let's presume the FBI accurately recounted her testimony to them. What would have been her interest in telling them that she didn't know about it while she was at State?
Well, obviously.
And our listeners are smart, they can figure that out too, but tell them.
Right. I mean, you have another senior official at the State Department who is aware of Secretary Clinton's emails. And the significance of Heather Samuelson is just going back to 2012, 2013 with the White House, Obama's White House, the crew FOIA request, the individual who the Obama White House was speaking with was Heather Samuelson. And from the documents, it's Heather Samuelson and Miss Walter, Cheryl Walter. However,
So Samuelson was still at the State Department at the time?
Yes,
She was there after Mrs. Clinton left for a
Yes, this is what the documents tell us, that they were in communication with the State Department. However, both Ms. Samuelson and Ms. Walter testified that they don't recall speaking with anybody at the White House about the crew request.
So irrespective of the White House, Samuelson at the State Department knew Hillary Clinton had email system. It was using personal emails to govern the business.
Yes.
Yet she was involved in an answer to a requester saying otherwise.
Well, she was definitely involved with respect to coordination as to how the State Department was going to be responding to crew.
So then she went over to the Obama White House to work in the White House counsel's office for a time, right?
For a year, approximately a year.
And then she went where?
And then she left the Obama White House in 2014 and became Secretary Clinton's lawyer.
And then she's the point person, by her own admission, on the email issue as her personal lawyer. Was she, my question before we get into that, was there a conflict there potentially because of her involvement with it at the State Department?
Well, I mean, that's a bigger question. So Heather Samuelson was hired by Cheryl Mills to work on this and become Secretary Clinton's lawyer. So we know that Cheryl Mills, upon leaving the State Department, has worked as Secretary Clinton's
Okay, so
lawyer.
you had two conflicted people, to put it charitably.
Right, so
I would say compromise rather than conflicted. But so Cheryl Mills hires Samuelson for Mrs. Clinton on the email issue.
Well, on other related matters, and then also the email issue.
What related matters?
I don't know. We couldn't go.
Are.
Well, we couldn't go into those in the questioning, but we did go into the specific email issue.
So the gig is up, whatever the phrase is, and Hillary's lawyer says, "Okay, we got to give the emails back to the State Department."
Okay. Well,
the emails we say we have back to the State Department.
Right, as early as July, late July, early August, Secretary Clinton and the State Department were in discussions about returning hard copies of Secretary Clinton's emails.
And we have those documents from other litigation we've talked about with Cheryl Mills was running interference in that regard. I mean,
that's an email from Cheryl Mills.
Yes.
So it's not even so much what the testimony of Heather Samuelson is, but we have the document. I mean, it speaks for itself.
So Samuelson was the leader on behalf of Mrs. Clinton, right?
Well, she worked under Cheryl Mills and David Kendall for reviewing, but Ms. Samuelson was the person who did the review of all of the emails.
So there's 60,000 plus emails. Right. In theory, well, did she talk about how she reviewed them?
Yes, she spoke about it. She initially did a review of the 60,000, and initially she looked at tos and froms and also did like an individual search, meaning searched all the emails by certain individuals, and then looking at the subject matter to determine if she thought those were State Department related. From there, she found about 30,000 or so to be state related.
And then, everything else she deleted without looking at them?
Initially, she deleted off her laptop, and then they were deleted from the FBI 302s. We know they were deleted from the server.
So go back, compare and contrast that process that she testified to what John Hackett, the State Department official, said should have happened,
Right.
which is an individualized review of each email.
Right.
Now, we're taking all this at face value, to be clear. I know there are people who suspect that they went and deleted emails purposely that they didn't want people to see, but this is what her testimony was. And there are enough legal issues with the deletion, irrespective of actually what the real story is. What she testified to is legally problematic, in my view, in terms of a potential criminal obstruction and other things. That's what the investigation was about. But what's incredible is, and I know there have been all these criticisms, rightly so, of the government handing immunity out to these Clinton email witnesses. So she deletes all these emails, and she talked about getting immunity.
Right.
Talk about that.
So she was provided, I don't know how, when we asked her about the immunity she was provided, she termed it as a partial document protection. I'm not sure, but in my world that's immunity by the DOJ. And that was provided, her testimony is that it was provided after she provided the interview to the FBI.
So she gets interviewed. She didn't get immunity for the interview.
No.
But evidently there's documents the FBI or Justice Department wanted.
Right.
And, she wanted immunity, or she received immunity before producing these documents.
Well, and well, it was after producing. So it was after the State Department, after Secretary Clinton returned the 30,000. But obviously, it was.
It was the interview. The immunity was given to her when?
In it was in 2015. 16.
June, was it June? It was June, wasn't it?
Yes.
And so Clinton was cleared when?
July.
So she's given immunity, granted immunity for the production of documents related to Mrs. Clinton's email usage, presumably the destruction of records. I'm kind of guessing here.
I mean,
but I mean, what would be the universe of records?
It's either destruction. It's either the records and the deletion of records, but it also can be with respect to having classified information in on unsecure systems.
Well, the State Department didn't care about that. I mean, we
No.
have all these emails showing they didn't care that David Kendall had classified material over there. Oh, do you have it in a safe? Oh, okay, that's good enough. I mean, just the double standard in terms of the lackadaisical approach towards the mishandling of classified information that they took, not only Mrs. Clinton but her lawyers, is unbelievable. So we're kind of burying the lead here. So the news is that the lawyer who deleted the emails for Mrs. Clinton, those 33,000 emails, got immunity from the Justice Department.
Has immunity.
And I don't think that's been public before.
I don't know if it was been that Ms. Samuelson received immunity before. I know that we've known about Cheryl Mills.
Cheryl Mills, the
other attorney
Right.
who was in charge of reviewing and seeing what to do with the other 30,000 emails.
Boy, so there's a lot we've uncovered.
Just one thing I just
Yeah.
want to correct. With respect, you are asking me about the process that Heather Samuelson undertook to review the emails. What I described was kind of the second part of the review to make sure that she testified was to ensure that she uncovered everything that was potentially government related. The initial review was just looking for anything .gov or .mil, but that's not of much significance because we know that Secretary Clinton and Jacob Sullivan communicated, and Huma Abedin, and
Chelsea
Cheryl
Clinton,
Mills,
and Chelsea Clinton.
Right. I mean, there were communications from non-state.gov to other non-government emails, communications about government business.
So this is all information that you're hearing about is a result of Ramona and 4 or 5 other colleagues on our attorney team here at Judicial Watch taking court-authorized discovery. And this isn't Judicial Watch who wanted these questions answered, whether Hillary Clinton used her system to avoid FOIA, whether the court was hoodwinked. The court wants to know whether Benghazi was one of the reasons for the cover-up. And as importantly, because it's a Freedom of Information Act case, well, where are there other emails potentially that we might have the right to access and have reviewed? And so we've gotten this incredible testimony implicating the Obama White House, both in the cover-up of her system, the State Department in the cover-up of her system, including allowing classified information to walk out the door potentially, just to protect themselves and Hillary Clinton, ignored warnings of the destruction of records that they allowed to take place despite knowing that was not appropriate. And then one of the key people who knew about her emails in the State Department and then did this slapdash review of her emails by her own admission gets immunity from the Justice Department after deleting 33,000 emails. Just incredible. And it's Judicial Watch that's getting the information out over the objections of the State Department and the Justice Department. Now, you know, we have videos of all these depositions.
We do.
But the State Department and Justice Department didn't want anyone to see them.
Right. So the State Department, as well as with respect to the former State Department officials, their individual attorneys had filed and had asked the court that their videos be sealed. So they're not subject to disclosure.
So right now, all you can do is look at the transcripts.
Correct.
So they're publicly available, and we don't know if the videos are ever going to be public. But this is one of the reasons, in my view, they didn't want the videos out there. It wasn't because they're interested in protecting the privacy of the deponents. It's because they knew this was going to come out. Because we have to remember, this isn't just a Hillary Clinton scandal. It's a State Department scandal. It's an Obama White House scandal. And as the court has noted, it's a Justice Department scandal. Right. Because we haven't asked for Justice Department attorneys to be deposed yet. So we've gotten all this material out. Justice Department opposes getting the material out. The State Department opposes, so we know where they stand on it. Congress is Congress, so they're not doing anything. The media thinks that we're not allowed to talk about Hillary Clinton, even though, in my view, the reason there's a Russiagate scandal is to protect Hillary Clinton from the consequences of her misconduct that we've uncovered here. So the court wants answers. So we've finished this round of discovery, and I guess the court said, you know, look, if you want to do something else, you're going to have to ask my permission. Right. And I don't know, are you in a position to share what you might want to do, or are you still
we're still reviewing,
moving the chess pieces?
We're still, there was a lot of discovery that was taken, so we're still going through everything. We don't want to ask for the same. Obviously, we want to make sure that, you know, we want to request just with respect to information we don't have. There are a few State Department officials that I think are very important for us to speak to. Judge Lamberth in his discovery.
So these are State Department officials that we found out more about their activities from the first round of discovery.
Correct, right. As a result of the discovery that we had now.
So there may be more State Department people we want to talk to.
Right. So Judge Lamberth said that he would hold a hearing after the discovery has closes. It's closed this first round, and we'll hold a hearing. And
well, I don't want to put you on the spot.
But you do.
But you know, people look. People are going to want to know: have we asked Hillary Clinton to come in under oath to testify? And have we asked for testimony in another case? The judge says we can propound written questions, and she answered under oath some of those questions. We have problems with that. Is there anything that would warrant bringing her in at this point, do you think, or are you still considering it, or?
We still have to finish looking through all the discovery that we have to see if
okay, so I put Ramona on the spot, and so she's not sure whether we're in a position to ask for Mrs. Clinton's testimony. Yeah. Now, you know, to be clear, you know, we may all want to emotionally want her to testify under oath about this. But the courts are skeptical, and they don't like bringing in senior former officials, and particularly Mrs. Clinton, for whatever reason. She's gotten a pass in many respects here. So it's going to be a tough haul to bring her in at this point, I suspect.
Yes, it will.
But we've got a lot of information she didn't want coming out.
Oh, I think we've got a lot of information as a result of this discovery. I mean,
so I want everyone to remember, how did we find out about Hillary Clinton's emails? It was through the work of this attorney, Ramona Kotka. I mean, I don't want to overstate it, but we talked about it. This is how the email system was uncovered, was through her litigation for Judicial Watch, and a federal court still wants answers and accountability. And Ramona is doing the work, and her colleagues at Judicial Watch is doing the work that the court wants done to get accountability in the Clinton email scandal. And I just hope that the new management at the Justice Department is finally going to wake up and take a look at this. I know they're fighting us in the civil litigation here, but if there's a prosecutor out there, testimonies here, of course these are all government documents, it's not like they have all the evidence, folks, don't worry. They know where it is, they gave it to us. So we'll see what happens there, but so we'll get our discovery, maybe additional discovery, and then we'll figure out what we want the court to do to give us relief for the misconduct that we uncovered.
Right.
Some incredible developments here. And we have exposed the Obama White House in this cover-up and the State Department involvement in this cover-up that involves the dangerous mishandling of classified information in a way that the FBI didn't do and the Justice Department didn't do. So kudos to you for doing that work.
Oh, thank you, Tom. But it's a team effort.
Well, I get to talk about all the good work the lawyers do. So you always see me talking about everything. I'm just talking about what lawyers like Ramona here at Judicial Watch are doing. And of course, we've got the investigative staff that have been helping us here too and reviewing all the documents, because there are hundreds and thousands and tens of thousands of documents in this case and related cases, because we have to look at everything that's come out.
That's right, because we've had other cases that have been relevant. I mean, with respect to the emails that were sent in 2014 to the Hill, we knew that because of a different lawsuit that we had,
Right.
and the records that were provided and as a result of that lawsuit.
So all of these documents are available on our website. I don't know how you'll find them all because there's so much of it. But you start searching Judicial Watch and Clinton and emails, and you'll start seeing the records I'm talking about. And the deposition transcripts that we're talking about are also all available. And I've been talking about those in recent weeks. So those will pop up as you go to our website and look for them. And hopefully they're readily apparent. But thank you, Ramona, for the time you took today to explain this to our supporters. And of course, I want to thank you out there, especially those of you who are supporting Judicial Watch, because this is the result of your heavy lifting in support of Judicial Watch. We're able to do the work that no one else here in Washington, D.C. is willing to do on this significant corruption scandal, which, as I said, has led to the worst corruption scandal of all time, which is the targeting of President Trump. It was all about, in my view, protecting Hillary Clinton. So until next time, thanks for joining us. I'm Tom Fitton, Judicial Watch President.